Annexure 7 Melrose at page 32 by compulsion there is a appointment on the basis of compulsory ground has been rejected and further for a direction.
Annexure 7.
Melrose.
What is the date of rejection?
It is of 22/6/1991.
Date of death?
Date of death is 29/6/1984. But prior to that, within time errors, the wife of the deceased employee has applied for the same.
What is the date of application?
That is of 1985 errors. It appears from Annexure 2 itself.
What is the age of the petitioner?
The present petitioner.
He is seeking compassionate appointment, na?
Yes.
What is his age?
Presently, he is around 54 years.
Sorry? What is his age? You have mentioned
51
years.
51 years.
Okay.
That's
He is 51 years in the year 2023, right? What was his age at the time of death of his father?
At that very moment, he is minor.
Okay.
Only one thing I would like to get so that in this case, basically the deceased employee was given the charge discharging his duty as charge worker and subsequently in the year 1984 his service has been confirmed.
1984.
1984.
1984 is the date of death.
And date of death also.
Okay. WPS number 3480 of 2023. The learned counsel for the parties are present. District petition has been filed for the following relief. The learned counsel for the petitioner submits that the father of the petitioner had expired on 26/6/1984 and on that day his services were already confirmed. Earlier he was working as work charge employee. He submits that upon his death, an application for compassionate appointment was filed by the mother of the petitioner for compassionate appointment of the petitioner in the year 1985, and the same has been rejected on 22/6/1991.
In fact, it was not for the this present petitioner. It is for herself itself. That is still pending. No order has been passed, and subsequently in the year 1991, the application was referred for appointment of my son.
अच्छा, उसको फिर से लिखिए थोड़ा सा, है ना? The learned counsel submits that in the year 1985, the mother of the petitioner had applied for compassionate appointment for herself, as the petitioner was minor at the relevant point of time, and subsequently in the year 1991, the petitioner attaining the age of majority had applied for compassionate appointment, and the same was rejected by order dated 26/9/1991, which is under challenge in the present proceedings. The learned counsel for the respondents has submitted that admittedly the petitioner was minor on the date of death of his father and much time has elapsed. There is therefore the very purpose of grant of compassionate appointment stands defeated. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the father of the petitioner expired on 26/6/1984, and the impugned order rejecting the claim for compassionate appointment is dated 22/6/1991. There has been inordinate delay in approaching this court, and in the meantime, the very purpose of grant of compassionate appointment, that is to tide the family from sudden crisis, is already over. Accordingly, this court is not inclined to grant the relief as prayed for by the petitioner in this petition, which is hereby dismissed.
This case, item 15, WPS 1621 of 2023.
Annexure 7 and Annexure 9 is under challenge. Annexure 7 is the termination letter, page 31.
There was already an order referring the matter for adjudication.
Non-district tribunal.
Yes, then what can be done about it? We can't do anything. This is
Matter
an
was
industry.
delayed already and COVID, in between COVID was,
We do not know what happened.
COVID was,
You explain it before the authority. We are not going to entertain the writ petition.
liberty.
Is 36 minutes?
Yes, 36. The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the respondents has submitted that the petitioner had already raised dispute in terms of the provisions of Industrial Disputes Act 1947.
Considering there was no, raised on the matter, only considering was there. So under section 2 of the industry.
Under section 2 capital A of Industrial Disputes Act. And petitioner was advised to file his dispute before the concerned Central Government Industrial Tribunal cum Labour Court Dhanbad. But the petitioner has not approached the state authority and filed the present writ petition. He submits that the petitioner, being a workman, has an appropriate remedy under Industrial Disputes Act, and the present writ petition involving disputed questions of facts may not be entertained. The learned counsel for the petitioner in response has submitted that the order by the certificate granted by the conciliation officer as provided under section 2 capital A of Industrial Disputes Act was 1947 was issued way back in the year 2019, and in the meantime there was COVID-19 situation, and therefore he could not move before the industrial tribunal. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court is not inclined to entertain the present writ petition on account of disputed questions involved in the present case, and also on account of the fact that the petitioner has appropriate remedy before the industrial tribunal. Accordingly, this writ petition is dismissed. I have a liberty. However, dismissal of this case will not have any bearing if the petitioner approaches the industrial, if the petitioner takes steps in terms of Industrial Disputes Act 1947 for redressal of his grievances.
The limitation may be.
कुछ नहीं हम बोल सकते.
Since we have disclosed our counter also we have filed. So
क्या करें इसको? आपको डिस्पोज ऑफ करने से ज़्यादा बिल मिलता है क्या?
नहीं डिस्पोज नहीं, हम बोल रहे थे कि आप जैसे वहाँ अप्रोच करेंगे तो ये they will say that I am having remedy over here. So my preliminary objection, another objection will be meted out otherwise.
नहीं, you see industrial disputes में whatever remedy you have, you can object whatever.
Yes.
So I've just said that he will have his remedy under 1947 Act, as per law.
Yes, yes, sir. We'll do it.
He can't do anything about it.
This case item 4, WPS 393 of 2023 along with item 5.
दूसरा वाला फाइल. I will dictate the facts today and finding tomorrow. Right? Okay, WPS number 6028 of 2022 with main base तो इससे हुआ था ना 393 से. हाँ, WPS number 393 of 2023 with WPS number 6028 of 2023. Your submissions have already been recorded in earlier orders. These two writ petitions have been filed for identical reliefs. With the following prayer for Padma. In WPS number 393 of 2023, there is only one writ petitioner, and in WPS number 6028 of 2022, there are 4 writ petitioners. Six. There are 6 writ petitioners. So far as WPS number 390, facts of WPS number 393 of 2023. The petitioner, being a trained teacher, was appointed as assistant teacher on 29/10/1994, and he gave his joining on 22/10/1994. The as per the provisions of the rules, namely, exact नाम बताइए रूल का हिंदी में है. What is the exact name of the rules?
Appointment rule, my lord.
Yes, 1993 rules.
My lord, Bihar Elementary Teachers Promotion Rule 1993.
Bihar Elementary
School Teachers
School Teachers
Promotion Rule.
Promotion Rules 1993, framed under Article 309 of the Constitution of India, and admittedly governs the petitioner. With regard to his promotion, the petitioner was granted promotion to. The petitioner was working in grade 1.
Appointed in grade 1. Later on, my lord, as per the eligibility criteria, 8 years, after 8 years, grade 4 has been
Okay.
granted with retrospective.
Just a moment. The petitioner was appointed in grade 1, and as per the 1993 rules, he was granted promotion to grade 4 by memo dated 9/10/2009 with retrospective effect, that is, with effect from 1/4/2003 along with other persons upon completion of eligibility criteria. The consequential benefits in terms of money was also given to the petitioner
First case.
so far as the promotion to grade 4 is concerned. With respect to promotion to grade 7, the petitioner was granted a promotion by memo dated 22/2/2019 with effect from 1/4/2009. However, no however, the respondents have denied the monetary benefit to the petitioners for retrospective promotion during the intervening period from 1/4/2009 to 22/2/2019. Right? Which is the cause of action to file the present writ petition. It is further case of the petitioners that once retrospective promotion has been granted, the consequential benefit arising out of such promotion cannot be denied to the petitioner. It is further the petitioner has relied upon the aforesaid judgments and has prayed for consequential monetary benefits. So far as WPS number 6028 of 22 is concerned, the petitioners of the said case where दो आदमी का डेट ऑफ अपॉइंटमेंट नहीं है, विजय कुमार एंड महेंद्र महतो.
Next case.
The petitioners
Date of appointment.
original appointment. The petitioners of the said case were appointed the petition number 1, 2 and 4 were appointed way back in the year 1994. Petition number 5 was appointed on 16/7/1988. And the date of initial appointment of petition number 3 and 6 is not clear. However, as per the records of this case, all the petitioners were granted promotion to grade 4 with effect from 1/4/2004, 1/4/2004, 1/4/2003. Yes, were granted grade 4 promotion in the year 2003-2004.
My Lord, may I permitted to interview? My Lord, the Baidyanath Ram, my Lord, he is appointed by memo number 3052 dated 9th July 88. This is the-
16/7/88.
my Lord, 9th July 88.
अच्छा, तो 9 जुलाई.
Appointment letter.
ये तो 5 का है ना, 3 and 6 का बताइए.
Fine. I'm searching.
And they were also granted grade 7 promotion to grade 7 on various dates. The aforesaid fact regarding each of the petitioners is presented in a tabular form as under.
Vijay Kumar is also 1994.
1994.
No.
Okay. और महेंद्र महतो,
Um,
महेंद्र महतो. महेंद्र महतो का भी बताइए.
I'm just
For these petitioners also, the monetary benefit out of promotion to grade 4 was duly granted. A promotion to grade 4 with retrospective effect was duly granted. The promotion was granted to them by memo dated 19/10/2019. इसका डेट नहीं पता चला.
मिनट annexure 1 में grade 4 इन लोगों को दिया गया था. Few petitioner मिनट page number 28 मिनट serial number 3 serial number 6.
Page number 28.
This is the grade 4 promotion.
The order of promotion of grade 4 is contained at annexure 1.
1 and 2 also.
1 and 2 of the writ petition, which is dated 5/8/2018
With retrospective effect.
and 5/10/2018. It was granted with retrospective effect.
Minute annexure 1 5/8/2018 and annexure 2 minute 19/10/2009.
Okay, annexure 2 is 19/10/2009. They were granted promotion with effect from the year 2003-2004. And they were also conferred with all the monetary benefit.
इस केस में मुझे उनको पता नहीं है. इनके केस में हम इंफॉर्मेशन नहीं है और प्लीडिंग में भी हम नहीं लिखे हैं. Therefore,
However, the
things
learned-
which is not in pleading.
That's right. However, the learned counsel for the petitioner during the course of dictation of this order has submitted that no specific averment has been made with regard to these petitioners as to whether they were conferred any monetary benefit or not arising out of retrospective promotion in grade 4. Further, the relief in the present case is not related to any retrospective promotion relating to grade 4. Right? The learned counsel, these petitioners were subsequently granted promotion to grade 7. Wide notification dated
Dated memo number 157 22/2019 annexure 3 page number 33.
wide memo number
157
157
dated
dated
22/2019.
22/2019 with different retrospective dates,
That is
and their grievance in the present case is that they are entitled for monetary benefit out of retrospective promotion for the intervening period till 22/2/2019. All of them are working.
Man, still working.
The learned counsel.
In first case, Milord, the petitioner is now retired.
Oh.
In this case, Milord, all are
When did he retire?
Milord, in first case, Milord,
Petitioner of WPS number 393 of 2023 has attained the age of superannuation after the grant of retrospective promotion to grade 7, and so far as the petitioners of WPS number 6028 of 22 are concerned, they are still working. The respondents have filed a counter affidavit in the present case. In both the cases, is it same counter affidavit? In both the counter affidavit in both the cases,
My lord, may I say, my lord?
taking
There are 7 my lord in first case. I have stated my lord 31/8/2021 को रिटायर्ड किया एज ए हेडमास्टर.
31
31/1/2021 from the post of headmaster come drying and dispatching officer at Government Girls Middle School, Rampur, Mangwadam within the district of Nadir.
he attained the age of superannuation at headmaster on 31/1/2020.
Right.
ठीक है? In both the cases, counter affidavit has been filed. दोनों केस में है counter. Taking similar plea, it has been asserted that the petitioners yes, it has been asserted as under as per notification number 2055 dated 30/9/1991
That is rule my lord.
हाँ.
1993
relating to Bihar Elementary School Teachers Appointment Rules 1991, which was amended by notification number 510 dated 5/5/1993. Advertisement was invited for trained and untrained candidates for appointment on the post of assistant teacher against sanctioned post of matric trained. The recruitment process was undertaken by Bihar Public Service Commission Patna, and after selection trained candidates were to be appointed. In the pay scale of matric trained of rupees 1200 to 2040 and untrained candidates under pay scale of 975-1560. The petitioners had appeared in the selection process and were recommended for appointment against matric trained scale in matric trained scale so far as WPS number 393 of 2023 is concerned, and so far as the petitioners in WPS number 6028 of 22 are concerned, they were given the scale of matric untrained and were sent for in-service training. And after conducting of teachers training examination by Jharkhand Academic Council, their result was published on 3/5/2002. Accordingly, as per clause 13 within bracket 3 of the promotion rules of 1993, they were granted the pay scale of grade 1 from the date of their passing of teachers training exam. So far as petitioner in WPS number 393 of 23 is concerned, the petitioner was pursuing teachers training, and after conduct of teachers training examination, his result was published on 22/2/1995. And in terms of clause 13 within bracket 3 of the promotion rules of 1993, he was also granted the pay scale of grade 1 from the date of passing of teachers training exam. Further, as per the rule 5 within bracket 2, of the rules of 1993, the petitioner in WPS number 393 of 23 was granted promotion in grade 4 scale with retrospective effect from 1/4/2003 by memo dated 9/10/2009 and was granted grade 7 scale with retrospective effect from 1/4/2009 by memo dated 22/2/2009, but monetary benefit of retrospective promotion was not granted. A reference has been made in counter affidavit filed in WPS number 393 of 2023 with regard to order passed by this court in WPS number 7392 of 2017 dated 26/9/2018, whereby direction was issued to amend direction amending earlier resolution dated 14/12/2015 18/7/2019 and 26/8/2021, wherein it was earlier mentioned that promotion granted earlier shall not be changed, but promotion on vacant post can be given with retrospective effect notionally. A reference has been made to an order passed by Honorable Supreme Court in Civil Appeal number 5573 of 2006 dated 4/12/2006 to submit that the promotional benefit can be granted only from the date of issuance of promotion letter. Another reference to another case has been made in judgment dated 8/3/2022 passed in Civil Appeal number 517/518 of 2017 to submit that promotion cannot be granted with retrospective effect and extended to give benefits and seniority from a date of notional vacancy. And so far as counter affidavit filed in WPS number 6028 of 22 is concerned, similar averments have been made. The learned counsels in both the cases have relied upon the decision dated 26/8/2021 which has been passed by the secretary, which has been passed by the respondent number.
My lord, this secretary in compliance of the, my lord, the
That's right. By the respondent number.
respondent, my lord, the one.
Respondent number 1, which in turn has been passed in compliance of order passed by this court in WPS number 7392 of 2017, directing the respondents to take uniform decision for extending the actual benefits of promotion to the petitioners of the said case within a period of 12 weeks. Upon perusal of the said decision dated 26/8/2021, this court finds that decision to the following effect has been taken. Roman 1, in terms of decision dated 14/12/2015, the decision of the department dated 14/12/2015 and 18/7/2015, the assistant teachers would be granted seniority right from the date of their appointment, and they would also be granted pay scale for grade 1. Roman 2, as per the provision of promotion rules of 1993, the promotion to grade 2 can be granted after completion of 12 years of service, provided the incumbent has completed the training full stop. Since the promoted post to grade 2 does not have, need not follow the reservation roster, etc. Therefore, the said promotion is as good as time-bound promotion, and consequently the arrears of salary for time-bound promotion to grade 2 will also be payable, right?
This is मतलब class. Grade 1, grade 2 का एरियर दिया जाएगा, grade 4 और grade 7 का नहीं दिया जाएगा.
That's right. इसीलिए लिख रहे हैं.
हाँ, इसीलिए
इसीलिए आपके सामने लिखा है.
Grade 1 and grade 2 are only financial abbreviation.
Yes, yes, yes.
This is the arbitrary action of the state.
Roman 3, as per provision of Rule 6 within bracket 1 within bracket 2 within bracket 3 of the promotion rules of 1993, the promotion to grade 3, grade 4 and grade 7 has to follow the availability of post as well as reservation roster.
Further, Milord,
Yes,
it
sir.
is the another case.
Just please hold on.
उसको
It has been observed in the decision that with respect to inter se seniority amongst the teachers, a number of litigation was pending before the High Court, and therefore the promotion to the assistant teachers there was hindrance in granting promotion to the assistant teachers, and the High Court has granted promotion to many teachers from retrospective date. One such order has been referred, that is WPS number 7779 of
It
2020.
is wrongly written as 7179.
Okay, 7179 of
The
2000
number is correct.
of 2011 within bracket Dinesh Chandra Mehto versus State of Jharkhand and others, and the corresponding LPA is LPA number 211 of 2019, and further SLP number is further SLP number 10742 of 2021. The directions given in WPS number 7179, यही number है,
No.
of 2011 to give monetary benefit on account of retrospective promotion has been retained. यही है?
That order, my lord, I have annexed in the
Yes.
annexed 3. my
The
lord.
order has been, please hold on. Accordingly, a decision has been taken that for regular promotion in grade 3, grade 4 and grade 7 on the basis of amended seniority list and on the basis of availability of the post, in principle, notional promotion is required to be given. And while taking this decision, a reference has been made to resolution number 1145 dated 18/7/2019, clause 7 within bracket Kh within bracket Roman 3, to take a decision that only notional promotion will be granted to such incumbents. ये 18/7/19 का हमको मिला नहीं सर्कुलर, कहीं भी रिकॉर्ड पर नहीं.
मिलोट 1100 पे तक हुआ क्या मिलोट? 3327 जो आया रेजोल्यूशन जिसको मिलोट अभी मिलोट ने कोट किया, इन दैट केस दे हैव टेकन आर्बिट्ररी डिसीजन कि अनुकंपा टीचर और अन्य को नहीं मिलेगा. देन दोज clause 15 is challenged before this honorable court by filing writ petition. They amended again that resolution by 1145.
नहीं, ये 1145 का resolution कहाँ है? रिकॉर्ड पे कहीं नहीं. It's not there.
Because
I've not been able to find out.
it is not relevant for the present case.
It is referred, so I was just
Madam.
wondering what is it. Roman 4 likhi.
Again, it is amended. It is again amended.
The resolution number 1145 dated 18/7/2019 has again been referred. Clause 7 within bracket K within bracket Roman 1 to take a decision that promotion granted earlier will not be cancelled, but retrospective promotion in case of availability of post will be granted from the date the incumbent is entitled for promotion. इसका क्या मतलब हुआ रोमन 4 का?
Suppose some district, they have granted grade 4 promotion in 2016-17, not following the eligibility criteria 8 years. In that circumstances, the several writ petition has been preferred and the direction has been given कि जो promotion 16 में या 17 में या 2015 में दिया गया है, it should be rectified and shifted to the date when they are eligible.
Okay.
But here, my case is my promotion is already granted as per the rule.
Just a minute. Roman 5. After granting regular promotion, the assistant teachers who do not join the post, who are not in a position to join the post, they will not be entitled for notional promotion also. Roman 6. After granting notional promotion, from the gradation list, that's right. The gradation list shall be prepared as per the rules of 1993 in terms of Rule 7 and 8, and notional promotion will be granted. इसमें तो कहीं नहीं लिखा है कि arrears नहीं मिले. Is it mentioned in this circular that no arrears will be paid on notional promotion?
It's not mentioned, but it has only said that only notional promotion will be granted.
वैसे लोगों को grant किया जाएगा जो notionally.
But nothing has been mentioned regarding arrears, isn't it? There is also a reference of earlier decision taken by the respondents in memo number 3027 dated 14/12/2015 as contained in Annexure C to the counter affidavit. Which was passed in compliance of order passed in WPS number 638 of 2006. Arun Sinha and others versus State of Jharkhand dated 4/4/2008, whereby the untrained teachers appointed in the year 87, 88, 94 and 99-2000 having educational degree of graduate on the date of their initial date of joining on the post of assistant teachers have been granted the benefit of grade 1 from their initial date of joining, but promotion in higher grades was to be considered in terms of the promotion rules of 1993.
Not relevant clause number 15, direction part is there, not
The
page number 33. इससे वो ग्रेड 1 सबको दे दिया गया नियुक्ति तिथि ट्रेंड
That's
अनट्रेंड
it.
का देयर इज नो एम्बार्गो मिला
okay. There is no order denying you the relief.
but it is granted only notionally. Fixation, benefit of fixation, monetary benefit has not been. In such circumstances, my lord, the honorable court has, my lord, annexure 3, my lord, I have.
We'll see that.
Ma'am.
Yes. In the judgment passed by the Honorable Supreme Court, reported in 1990 within bracket 2 PLGR
Lord,
248.
it is
You will
Patna-
order. This
Lord,
is
it is Patna High Court Division.
Patna. Yes. By Honorable Patna High Court, in the
Ma'am.
case of Dr. Paras Nath Prasad versus State of Bihar.
Ma'am.
Which has been relied upon by the petitioner. The petitioner of the said case was appointed as civil assistant surgeon on 28/5/1955 which was a post born in the cadre of State Health Services and was entitled to be posted next below his immediate senior in service. In the gradation list. And in such circumstances, he filed a title suit. And the suit was decided by judgment dated 23/2/1983 in his favor. And thereafter, amalgamated list was prepared. Against the judgment and decree of the Munsif, appeal was preferred and the judgment was affirmed, and thereafter a second appeal was preferred to the High Court. And ultimately the matter went up till the Honorable Supreme Court. Consequently, the decree of the additional Munsif was ultimately affirmed. The इसमें issue कहाँ frame हुआ था? Where was the issue framed?
Not in the suit.
Issue. This court has considered the Honorable Division Bench of Patna High Court considered the argument advanced with reference to Rule 58 of Bihar Service Code, which prohibited grant of any pay and allowance on fictional and notional promotion granted, and the said plea by referring to or plea of reference to Rule 58 was negated by the Honorable Division Bench.
Para 19.
By para 19 of the said judgment. By holding that a person who is entitled to promotion and is not promoted can always invoke the jurisdiction of Article 226 of the Constitution of India for a mandamus upon employer state to consider his case for such promotion, and such due promotion is not a claim of anything notional, but it is something which is attached to the status of service contract of the concerned employee. The Honorable Division Bench ultimately concluded that the petitioner of the case was entitled to be promoted to junior selection grade, senior selection grade and super time scale of pay with effect from due date, and was also entitled to receive the difference of pay at each selection grade of promotion and fixation of pay including super time scale of pay, and also fixation of pay in the super time scale of pay for the purposes of determination of pension, gratuity, etc. with effect from the due date. The Honorable Division Bench has also observed that once it was found that the petitioner was entitled for promotion, it was not clear from the records as to why the respondents did not give promotion to the petitioner in terms of senior selection grade, super time scale, etc. The Honorable Division Bench also took into consideration that the juniors were promoted one after another to junior selection grade, senior selection grade, super time scale of pay, and even made Director in Chief or Director of Health Services, while the petitioner was given the post of Deputy Superintendent in the lowest grade of scale of pay. And the Honorable Division Bench was of the view that the respondents have denied the petitioner's right of equal protection of law and equality before law in the matter of employment and violated Article 16(1) and 14 of the Constitution of India. In another judgment passed by Honorable Patna High Court, in judgment reported in 1991 within bracket 1 PLJI 272, Ranjit Sahai Jammuar versus State of Bihar, the provision of Rule 58 of Bihar Service Code and Rule 74 of Bihar Financial Rules was fell for consideration. And in the said case, the petitioners were granted promotion with retrospective dates after their retirement but were denied monetary benefit accruing out of promotion. It was observed in the it was in the said case that the petitioners had moved the court earlier in CWJC number 2104 of 1982, and the judgment was passed on 9/3/1995, which was subject matter of LPA number passed. And ultimately the decisions were made in favor of the petitioner and a direction was issued that the petitioner's seniority was redetermined and consequently their orders of promotion were issued. The Writ Court considered the judgments passed in the case reported in 1990 within bracket 2 bracket close PLJI 248 Dr. Parasnath Prasad and observed that an employee being given promotion with retrospective effect cannot be denied the monetary benefit accruing from the promotion the provision of Rule 58 of the Service Code and 74 of Bihar Financial Rules were held to be not applicable by citing reasons by paragraph 7 of the said judgment, which is quoted as under. हमें para 7 quote करना है from PLJR से, ठीक है? In the judgment passed by this court in the case of Dinesh Chandra Mehto,
State versus Dinesh Chandra Mehto, LPA number 200.
State versus Dinesh Chandra Mehto,
Page number 14
in
petition.
State of Jharkhand versus Dinesh Chandra Mehto in reported in 2020 within bracket 3 bracket close JBCJ 604 HC. The matter was relating to the the assistant teachers as involved in the present case also. Same hai assistant teachers? In the said case, this court after this court has referred to the provisions of Rule 58 and Rule 74. Rule 58 of the Bihar Service Code and Rule 74 of Jharkhand Financial Rules. And was of the view that the learned single judge cannot be said to have committed any error in not accepting the reasons for denying claim of the writ petitioners by applying Rule 58 of the Service Code and Rule 74 of the Financial Rules. इसमें जो है पैरा 12 and 13 में ना quoted है Rule 58 of the Service Code and Rule 74 of the Financial Rules. In the said case, the writ petitioners were having the requisite qualification of metric trained and were appointed to the post of assistant teacher in metric trained scale in the year 1975, and they subsequently passed the examination, the training examination in intermediate examination in 1978, and subsequently the BA and Master's examination in 1983 and 1992. The writ petitioners having passed the requisite examination were claiming promotion to the various posts as per the rules, and their claim was that they should be granted promotion from the date juniors to the writ petitioners were granted the scales, and from the date the juniors were promoted. In such circumstances, an appropriate order was passed by the learned writ court in 3986 of 1999 within bracket R on 23/7/2001, wherein appropriate direction was given with regard to grant of promotion to them from the date the juniors were granted the benefit. But the order was not complied, and contempt application was filed, and they were given the promotion with retrospective effect on the day their juniors were granted such benefit, but arrears of monetary benefit were denied to them. This court, while considering the facts of the case, has recorded in para 19 that if there was no fault on the part of the writ petitioners and writ petitioner and his case of promotion was not considered, rather junior to him were promoted. And if such employees approach the court of law and is granted promotion, can such employees be denied monetary benefit of retrospective promotion? This court observed that it was not in dispute that promotion is not a fundamental right, rather consideration of promotion is a fundamental right. And was of the view that the petitioners could not be denied monetary benefit of such post, as because if the case of the petitioner would have been considered at the time when the cases of juniors to him were considered, he would have been granted the promotion with all consequential benefits. And it was not the case of the state that the writ petitioner was not eligible for promotion, and there was no fault on the part of the writ petitioner. It was also observed that if the monetary benefit under such circumstances is denied, same would amount to hostile discrimination by treating the writ petitioner differently as compared to that of his junior who was already granted promotion. It was observed that under such circumstances, the principle of it was also observed that the principle of no work, no pay is not universally applicable, particularly when there has been no fault on the part of the employee. And ultimately, the Honorable Division Bench, with regard to applicability of Rule 58 and 74, 58 of Jharkhand Service Code and Rule 74 of Jharkhand Financial Rules, held as under Para 24 and 25 for court condition. In another judgment passed by this court, reported in the case of Suryadev Prasad versus State of Jharkhand, reported in 2010 (3) JLDR 185. The aforesaid rules of Jharkhand Service Code and financial rules were considered, and it was observed that withholding of promotion due to pendency of departmental proceeding and on account of subsequent promotion granted to the petitioner of the said case, he would be entitled for all financial benefits from backdate. In the judgment passed by this court in WPS number 1932 of 2005, within bracket Rajeshwar Prasad versus State of Jharkhand, the matter was relating to promotion of superintending engineer and in the said case the financial benefit was extended with effect from the date on which the juniors were granted junior was granted promotion, and in view of the aforesaid judgments, it is the case of the petitioner that petitioner is entitled for monetary benefit for the promotion granted to the petitioner with retrospective effect. Is there anybody who has been granted promotion junior to you?
In the present will not record not and the person will not be who had earlier granted such promotion. Now they all are now retired.
They are enjoying their
For a long
promotion.
period, my lord, there was no promotion to the grade 7 after the appointment of these petitioners.
So there could be some persons who were granted promotion by virtue of the orders of this court, and in spite of the fact that the petitioners are placed higher in terms of seniority, but they have been granted the benefit. Possible? It is district-wise gradation.
It is district-wise gradation, my lord, and in the Latehar district, my lord, where the petitioner belongs, my lord, entire promotion, my lord, up to 2019, the last date of the order passed, my lord, lecture 2 and 3, has been granted. But now there is no due promotion. After 2019, there are some persons, my lord, to whom, my lord, the promotion is to be considered and granted by the authority. But up to 2019, there is no. All eligible persons are granted.
So far as the respondents are concerned, they have relied upon the judgment passed by the Honorable Supreme Court in the case of Civil Appeal number 517-518 of 2017, Sukta, and also the judgment in Civil Appeal number 5573 of 2006, Sukta, and the judgments passed in the case reported in bracket 1996 bracket close 7 SCC 533 State of Haryana versus O.P. Gupta, and judgment reported in bracket 2007 bracket close 15 SCC 777 and have heavily relied upon Rule 58 of Jharkhand Service Code and Rule 74 of the Financial Rules. To submit that, the said rules cannot be ignored, and it is not the case of the petitioners that any junior to the petitioners have been granted the relief, and the petitioners have been denied similar relief.
Also, Your Ladyship, that promotion to grade 4 and grade 7 are post promotions. That's not a financial upgradation.
The
So
learner,
unless a
it
person
is also the case of the respondents that promotion to grade 4 and grade 7 are cadet promotion,
post promotion.
are post promotion, and are not financial upgradation, and promotion from grade 1 to grade 2 is financial upgradation, and therefore the retrospective benefit of retrospective monetary benefit has been granted upon grant of such promotion, but the same principle would not apply for grade 4 and grade 7. it has also been indicated that the judgment, the base judgment which has been relied upon by the petitioner regarding selection grade, junior selection grade, senior selection grade are also financial upgradation are not related to post promotion. Is it financial upgradation?
पोस्ट प्रमोशन था
Junior selection grade and senior selection grade.
पारसनाथ में जो जजमेंट किया
So it was only junior selection grade and senior selection grade.
not that not the other person has been granted to the post of director.
Right. Okay. That is all. कल लिखाएंगे. Okay, कल नहीं परसों.
ठीक
Because he will take some time
परसों
to.
तो छुट्टी है उसके बाद
विदित जी हम कब रख दें?
ठीक जब पायलट का
Right? रिकॉर्ड किए हैं कि नहीं? हाँ? दोनों जने पार्ट करके कर लेंगे? You have not taken the हेडफोन लगा के नहीं करते हैं आप? कर लेंगे ना थोड़ा पार्ट करके कर लेंगे.
नेक्स्ट मंडे को भी रख दिया
नहीं इसको ना ज़्यादा दिन नहीं
फ्राइडे
करेंगे.
को फ्राइडे
मंडे को रखेंगे. मंडे को रखेंगे. Post this case for further dictation on Monday. उस दिन आप लोग कुछ मत बोलिए.
नहीं कुछ क्यों
उस दिन हम एक बात आप लोग का नहीं सुनेंगे.
फैक्ट्स पर केवल पायलट हम लोग असिस्ट किए आप भी
हाँ.
कुछ भी हम लोग ही नहीं
क्योंकि I know that this matter is going to affect large number of persons. Therefore, I thought that it is better to have dictation in the open court. कुछ तो decide करना है.
May not pass order on this issue, my lord. The state is, my lord, used to pass casual orders in this regard, my lord. One hand, my lord, 30 years they are not granting promotion, they are not complying with the rule. Another hand, my lord, when the my lords, the honorable courts are passage order, they are granting notionally, only on paper.
अच्छा.
This is the, my lord, the
And there was no stay regarding promotion in any of the cases. There was no stay regarding promotion. ये कौन सा है? इसी के लिए बोले थे. हाँ, हाँ, that's right.
Final disclosure item 2, WPS 51 of 2023.
Yes, petitioner. You have filed SLP. You have filed LPA.
Yes, Lordship.
Those are pending.
Lordship, 2 LPA we have mentioned in this counter affidavit, and further 3 more LPA has been filed, Lordship.
May I submit one thing? So with regard to this issue matter, this issue is apart from the Supreme Court also.
That's right. They have filed LPA, no? After following that, we have to wait for the LPA
One
order.
more preliminary objection we have taken of Lordship, these petitioners are being the fence sitter, Lordship. Since these matters are coming quite a lot of long time, Lordship, and this after the orders has been passed, these petitioners are now being aggrieved, not aggrieved, Lordship, since the order has been passed for payment of salary to these petitioners. To the earlier petitioner who came before this honorable court, Lordship, now they are also coming.
It is regarding payment of salary only.
Yes, Lordship,
You
but
see, we always pass the order that
My-
it is subject
my
to
lord's order,
verification
this
of the
Lordship, but we
records.
have taken.
My
No,
lord,
we will
my
wait for
lord has
that.
decided, and they have also deposited the amount before register also in contempt. And the similar issue, more than 15% they have paid, and they have not filed any LP. And in the division bench, all this fact has brought on record that why they have not filed.
What is happening in the division bench?
Lordship, in the division.
Nothing, my
matter-
lord, still it is defective.
Lordship, the
It's
defect.
defective?
Defective,
Yes,
my lord,
Lordship,
yesterday contempt,
The defect is with
therefore
regard
they
to
have
Lordship,
deposited the amount.
limitation petition has not been filed, Lordship, since we have filed for the certified copy of the order and we are not getting it, Lordship.
and they have
It is-
deposited this amount.
That's right.
Certified copy of the order?
Yes, Lordship, a certified copy of the order of the single bench, Lordship. And that's why we are not able to.
So for certified copy of single bench order, that is automatically deducted.
No, Lordship, we have to file limitation petition since limitation period has been exceeded, Lordship. And we have to file that only.
Certified copy of my orders also you are not getting.
Lordship, I have to.
My lord's
see
order
that.
is also challenging LPA, but
Yes,
in
Lord.
contempt
It's good. They should challenge it.
they have
Lordship,
already complied.
since
They
not
made-
complied, Lordship. That money has been submitted before the registrar.
Under protest must be.
Yes, Lordship.
Surely under protest. We'll wait for the result of LPA. See,
And
we
your
cannot
lordship-
file, we cannot pass orders which are subject matter of consideration.
But
You have to wait for some time.
Yeah,
You have
I-
waited since 1999. What's the big deal about it? Wait for a few more months.
all
You expedite the hearing.
two of the paid manager have already died. Their widow has filed for arrear of salary. This
अच्छा है
is the
कि
situation.
दो
And-
generation बाद नहीं file की.
नहीं, दो generation
That
है तो-
itself shows that
Well,
you are a
earlier
failed
they,
citizen.
earlier they have filed the writ application. During contempt application they were rejected. Then it is challenged before the lawsuit. And several order, even my lord, it has
The learned
affirmed
counsel
to
for the parties are present. The learned counsel for the respondents has submitted that the orders on which the petitioner is relying are subject matter of consideration in number of LPAs, including LPA number 569 of 23 and 570 of 23,
And 1613 of 23.
and also
613.
613 of 2023. The learned counsel for the respondent submit that though the latest patent appeals are defective, but expeditious steps are being taken by the respondents to remove the defects in the LPA, and he prays for adjournment. How much time do you need?
4 weeks.
4 weeks में आपका LPA decide हो जाएगा.
नहीं decide तो नहीं होगा, at least it will be taken.
आप appear कर रहे हैं, सब में तो आप ही हैं. अब नोटिस के लिए अगर आप पेंडिंग रखेंगे तब तो बहुत मुश्किल
अभी
है.
तो इनका डिफेक्टिव है, move नहीं हुआ. लिमिटेशन पिटीशन तक फाइल नहीं.
आप तो अपीयर हो जाइए ना वकालतनामा लेके अपोज करने के लिए. आप जानते हैं नोटिस तो होना चाहिए, होगा भी. वी डू नॉट नो. Pose this case on 12th of August.
12th August.
The parties to produce the present status of the status of the LPA on the next date.
Item 6, WPS 2739 of 2023.
This petitioner.
They appear on behalf of the state Lords. On the last occasion, there was a direction to file the counter appeal. Lords, we have not received the instructions yet. I am seeking for 2 weeks time as last interview.
My lord, already direction was given to file counter affidavit before 21st of March, my lord. But till date they have not filed.
Lords, only one
Were you there on the last date?
Yes, ma'am.
Were you there on the last date?
Yeah, I was on legs before another court. I prayed just after the case, my lord.
So you don't insist on the order passed in your absence, which was in your favor. Okay. How much time do you need?
That's 2 weeks.
WPS number 2739 of 2023. The learned counsel for the parties are present. Counsel for the respondents are prayed for and are granted time till 29th of April 2024 to file a counter affidavit in the present case by way of last indulgence. Post on 30th April in the supplementary cause list. उस दिन मत मांगिएगा टाइम.
I am respondent number 2, my lord. Deoghar Municipal Corporation, I have filed counter.
Your file, what is your stand?
My lord, he is on deputation, my lord.
अच्छा.
Father of the petitioner, husband of the petitioner was deputation in my municipality.
Item 7, WPS 3545 of 2023.
In this case, when the director took files, we have taken time to file rejoinder. We could not file this thing, so 1 month is
same order कर दीजिए by way of last indulgence rejoinder to of the petitioner, right? WPS number 3545 of 23, counsel for the petitioner, prays for in his and is allowed time till 29 of April 2024 by way of last indulgence to file a rejoinder. Post on 30th in the supplementary process. Next.
Item 8, WPS 5306 of 2023.
Lordship, on last occasion, Lordship directed to file specific counter as well, Lordship. Lordship counter is waiting for approval before the PC, Lordship. So kindly give me 1 week.
आप लोग जो बिना एडवांस नोटिस लिए टाइम लेते हैं ना, अगला हफ्ता से बंद कर दीजिए. टाइम मांगिएगा विदाउट एडवांस नोटिस, इट विल बी गिवन ओनली ऑन कॉस्ट. ओके, बोल दीजिएगा सरकार को. Counsel for the parties are present. Time till 29 April is granted to the respondents to comply the order dated 20th March 2024 by way of last indulgence post on 30th April. The supplementary process.
Item 9, WPS 7114 of 2023.
This matter, respondents have taken time and last opinion to file supplementary counter affidavit and we have to file reminder to that effect by 10th, but they have not filed.
Where is the respondent? Respondent HGC.
5-3.
Counsel for the petitioner is present. Nobody appears on behalf of the respondents. In spite of order dated 5/3/2024, no supplementary counter affidavit has been filed. Counter affidavit was to be filed by respondent number 4 and 5.
4 and 5. Number 2, 3 to 5. 2, 3 to 5.
This is promotion to what post?
Legal probation officer, my lord. He selected, result is circulated, he had minister to only issue it to issue the offer of appointment. And they have issued trace advertisement, my lord. Even DB judgment is on this point, my lord. At this stage, the process cannot be stopped.
Which is that judgment?
My lord.
Which is that judgment? dismiss this case tomorrow. कल आने दीजिए, देखते हैं क्या टाइम मांगते हैं, क्या
The
करें.
leadership can inform the state office.
What will you inform? That the matter is posted tomorrow? Because you do not know how much time there comes. Why don't you file your supplementary counter affidavit?
Lordship, I have informed the DSW, Lordship. The problem is the DSW has some hearing problem, Lordship. And therefore, they have not responded as per the time given, Lordship.
Should I record this?
Tomorrow. It need not be recorded,
Then
Lordship.
hearing problem है तो आपका फोन पे बात नहीं सुन.
आप क्या बोले हुजूर, आप सब जानते हैं. तो आज हम लोग सुबह में आपको पता है हुजूर कैसे होता है. आज सुबह उनका है कि वो लोग एक बार एक चांस दिया जाए वो लोग.
उनको हियरिंग प्रॉब्लम को बोलिएगा कि आँख का प्रॉब्लम ना रखें, ऑर्डर में लिखा हुआ है क्या करना है.
जी हुजूर, हम ऑर्डर भी भेजे हुए हैं. एक चांस दिया जाए हुजूर.
उनको बुला लेते हैं. आई होप मेरी बात उनको सुनाई देगी. कौन है बताइए जिनको हियरिंग प्रॉब्लम है?
क्या DSW है मैडम.
बताइए.
एक चांस दिया हुजूर. 2 वीक का समय हम लोग काउंटर फाइल कर देंगे जो भी कोर्ट
आज जो सिलेक्शन प्रोसेस हो रहा है उसका क्या करेंगे? उसको फिल कर देंगे.
वो तो हम कोर्ट का जो व्यू था हम सूचित कर दिए थे.
नहीं तो ये नहीं हो सकता ना कि सिलेक्शन प्रोसेस को आप फ्रस्ट्रेट, मतलब इनके रीड को आप फ्रस्ट्रेट करके सिलेक्शन प्रोसेस में डिसाइड कर लीजिए किसी को देने के लिए. ये तो नहीं हो सकता ना.
हुजूर ऐसा इसमें होगा कि नेक्स्ट वीक मंडे को रख दिया जाए. जो भी होगा कोर्ट को बता दो, जैसा भी होगा. अगर वो कुछ करेंगे तो ठीक, नहीं तो जैसा फिर आपके पास.
At this counsel for the petitioner prays that the matter be posted on Tuesday. Right? The affidavit in terms of order dated 5/3/2024 should be filed by Monday, failing which the respondent number बताइए कौन आएंगे? 4. Respondent number 4 से क्या होगा? पहले affidavit किसने फाइल किया? Respondent number 2, 3 and 5.
The relevant parties responding to 4.
Respondent number 3 को बुला, तब आ जाएगा आपका काउंटर.
और कोई फाइल कर देंगे लोग जो भी होगा. सब्जेक्ट टू कर दिया जाएगा.
Failing which the respondent number 3 shall appear before this court to explain as to why the orders passed by this court is not being complied. The counsel for the state is directed to immediately communicate a copy of this order to the respondent numbers 3, 4 and 5. सौरभ इसको जो है टाइप करके ले आइए, किसी और स्टेनोग्राफर को बुलाइए, साइन कराइए, अपलोड करिए. Post on Tuesday next time. Supplementary problems.
For admission item 36, Kidwell Division 1128 of 2019.
They appear from the state.
What about the petitioner?
Petitioner is the informant, Lordship, complainant. Lordship declared the criminal revision and filed against the appeal, whereby the opposite party has been acquitted.
This is appeal against acquitted. It is not maintainable.
I am the state of the state. Lordship, the CRMP number 1928/2000, which was withdrawn by dated 29th November 2018, and the acquittal appeal has been already dismissed, DFD dismissed for default by the honorable bench, by this court.
In arising out of same case.
Lordship.
That is.
This is the Lordship, para number 2 of this petitions, Lordship. On page 4, petitions, para 2. 2 times books. First CRMP 1928, which was
Appropriate application by the acquittal appeal
acquittal appeal number such and such and the same has been
एक्यूटल अपील होने के बाद इसमें क्या रिविजन कैसे फाइल करनी है?
ये रिवीजन फाइल के रिवीजन फाइल अगेंस्ट द क्रिमिनल अपील नंबर 27/2012 बाय लर्नेड एडिशनल सेशन जज अगेंस्ट द
एक्यूटल अपील तो उसी में फाइल किए होंगे ना? एक्यूटल अपील तो इसी ऑर्डर के अगेंस्ट में फाइल किए होंगे ना, क्रिमिनल अपील के अगेंस्ट में।
क्रिमिनल अपील जो लर्नेड सेशन जज के
हाँ।
अगेंस्ट ये रिवीजन फाइल हुआ
नहीं, ये एक्यूटल अपील किसके अगेंस्ट में फाइल की? Where is the order dismissing the acquittal appeal?
यहाँ फाइल हुआ था, ये फाइल हुआ है acquittal appeal page number 31 against the appeal. This revision is filed against this appeal.
31
31 page number 31 criminal appeal number 27
हाँ,
2000
इसी के अगेंस्ट में नहीं,
इसी के अगेंस्ट में रिवीजन ही फाइल किया।
तो उसी के अगेंस्ट में एक्यूटल अपील फाइल की है, वो डीएफडी हो गया, अब उसी के अगेंस्ट में रिविजन फाइल कर रहे हैं, कैसे चलेगा ये? ये नोटिस का स्टेज में आया है क्या?
इसमें एक्चुअली नोटिस जो लोग गया है वहाँ पर नोटिस लगा हुआ है, तो लोग डेट कर गया सब, कुछ लोग डेट
आप आए हैं, बोलिए। टाइम तो हम आपको देंगे, लेकिन जिस ऑर्डर के अगेंस्ट में आपने एक्यूटल अपील फाइल किया वो डिसमिस फॉर डिफॉल्ट हो गया, उसके अगेंस्ट में आप फिर सेम ऑर्डर के अगेंस्ट में क्रिमिनल रिविजन फाइल करती है, इसका क्या मतलब है? और क्यों करती है? एक्यूटल के अगेंस्ट में रिविजन कैसे लाई करें?
रिवीजन उससे सीआरएमपी फाइल किए थे लीव लेने के लिए, तो उसमें जजमेंट आया था कि ऑनरेबल कोर्ट का कि आप लीव नहीं, आप क्रिमिनल रिवीजन लाई करें।
कहाँ है ऑर्डर?
एचसी मिश्रा साहब का ऑर्डर था इसमें।
कहाँ है?
डीवी का ऑर्डर
कहाँ है ऑर्डर? फिर आपने एक्यूटल अपील फाइल कर दी, उसके बाद सीआरएमपी के बाद आपने अपने एक्यूटल अपील फाइल कर दी, जो डीएफडी हो गया, उसके बाद आपने रिवीजन
तो रिवीजन ही लाई होता वो था मैटर, हमें आपको डेट दे हम दिखाएंगे
18 तारीख, सारे मैटर्स आ रहे हैं 18 तारीख।
2 हफ्ते टाइम,
2 हफ्ता प्रोविजन ऑफ लॉ एग्जामिन करने के लिए 2 हफ्ता आपको टाइम चाहिए।
तो इंस्ट्रक्शन भी लेना है,
इंस्ट्रक्शन लेना है, उसके लिए हम लोग टाइम नहीं देते। Our provision of law criminal revision is not maintainable against order of acquittal.
ठीक है।
The counsel for the parties are present.
मंडे को रख दीजिए।
18 तारीख को बहुत सारे मैटर्स हैं।
मंडे को रख दीजिए अगर कन्वीनियंट हो।
आप हैं, आप उसमें थे ना 166 में? नहीं, वो क्या नाम है उनका? आप थे ना, नॉट मेंटेनेबल क्रिमिनल रिविजन। एक मैटर में आप थे ना, क्रिमिनल रिविजन वाज हेल्ड टू बी नॉट मेंटेनेबल अगेंस्ट एक्यूटल। आप ही तो आर्गुमेंट किए थे, क्रिमिनल रिविजन वाज नॉट मेंटेनेबल अगेंस्ट एक्यूटल। हम डिसाइड किए 166 में। क्या नंबर है? 661। आपका नाम पंकज है? जी। आप ही थे, आपको याद नहीं है ना? ऑर्डर भाई, एक ऑर्डर का कॉपी रखा करें। पंकज श्रीवास्तव।
यस पंकज।
कोई और? जोसेफ स्टीफेंस वाले केस को रिलाइट किया इसी में। देखिए, criminal revision number 1128 of 2019. This revision has been filed against judgment of acquittal passed by the appellate court. From the records of this case, it appears that a acquittal appeal was filed which was dismissed for default against the same order. Counsel for the respondents has submitted that the present revision is not maintainable. Counsel for the petitioner prays for time to examine the matter. क्रिमिनल रिविजन नंबर 661 ऑफ 2022 भी देख लीजिएगा, ठीक है? Post this case on 18th.
19 कर
19 नहीं कर सकते, 18 तारीख को बहुत सारे मैटर्स लगे।
क्या
Criminal division.
Criminal revision number 661 of 2022. 2022 decided on 23/2/2024.
Item 37, WPS 130 of 2023, along with item 38.
आप अभी सर्विस में हैं?
जी. My lord, everything has been completed except a notification has to be issued. That is, of course, it is a ministerial work. But the state government, in exercise of which power I don't understand, madam, they are saying that the office of Lokayukt will be governed by me and you have no competent authority to issue notice in respect of promotion. Your lordship, may kindly see page 40.
What is the cause of action in these cases?
Yes, I am just reflecting. The impugn order is annexure 9, page 47.
Give me some background, please. Give me some background of it.
Yes, that is what I am reflecting. Your lordship, may kindly see page 39.
Page number?
Page number 39, annexure 6.
39. Yes.
Relevant is page 40. This is the proceeding of DPC, my lord. Paragraph 2. विभागीय प्रोन्नति समिति द्वारा उपरोक्त तथ्यों के आलोक में विचारणीय क्षेत्र के अंतर्गत नामांकित उम्मीदवारों की प्रोन्नति के बिंदु पर विचार किया गया। विचारोपरांत सूचीबद्ध उम्मीदवार के संदर्भ में विभागीय प्रोन्नति समिति ने निम्न रूपेण अपना अनुशंसा गठित की है।
Found entitled.
Found entitled. उसके नीचे का 2 लाइन देखिए, पैराग्राफ 3 उल्लेखनीय है कि कार्मिक प्रशासनिक सुधार एवं राजभाषा स्वयं पत्रांक के द्वारा राज्य सरकार की सभी सेवाओं एवं पदों की प्रोन्नति पर अगले आदेश तक के लिए रोक लगाई गई है। अतएव इस संदर्भ में कार्मिक प्रशासनिक सुधार
ये तो सेट असाइड हो गया।
सेट असाइड हो गया है, एलपीए भी कंफर्म हो गया है। यस, नाउ योर लॉर्डशिप में
उसके बाद इनका सर्कुलर भी आ गया है, रिलैक्सिंग रूल 58 and 74.
And the government is issuing notification in respect of the employees of the state government, but they are keeping a tenterhood on us, the office of Lokayukt, saying that आप secretary को, मेरे secretary office को, कि you cannot authorize to issue notification despite of the fact that the promotion committee has been recommended your case. Annexure 9 your lordship mechanism. That is impugned.
You are working in Lokayukt
Yes,
office?
I am a separate cadre. I am controlled by the Lokayukt office. Lokayukt is my head of the. In fact, under the sad demise of Justice D.N. Upadhyay, the post is vacant. But the constitution of the committee was prior to his death, and he has constituted that DPC. 5 independent members.
Yes, there is already a recommendation.
Yes, but
the recommendation was not taken to a logical end only because of that order.
That notification,
That
and that
notification
notification is hindered by annexure 9, the impugn order.
Annexure 9 is the impugn order.
Yes.
Okay.
Relevant is page 48, I think.
Yes.
He has referred to clauses of the Act. अतः उपरोक्त प्रावधानों के आलोक में माननीय लोकायुक्त झारखंड का पद रिक्त रहने की स्थिति में लोकायुक्त के सचिव को कार्यालय के कर्मियों को प्रोन्नति संबंधी कार्यों के निष्पादन हेतु प्राधिकृत किए जाने का प्रस्ताव लोकायुक्त नियम 2001 तथा झारखंड लोकायुक्त इतना नियमों के अनुकूल नहीं है. That means they are indirectly controlling the office of the secretary of the Lokayukt. And this is not the object of the Lokayukt Act. Now your lordship may kindly see.
So you see, in absence of the Lokayukt, how your promotion can be given effect to without the
Your lordship may kindly see page 55. I have enclosed the rules. That is the Jharkhand Lokayukt Condition of Service Rule 2001. Annexure 11, page 51.
Yes.
Your lordship, relevant is page 55.
Yes.
Clause 25. Head of the office. The secretary shall be the head of the office of Lokayukt. There is no control by the State Department. Under what capacity the secretary of the Rajbhasha is informing the secretary that आपको ये power नहीं है. And your lordship has seen just annexure 6. Your lordship may just bear with me, and annexure 5 your lordship may kindly see. Annexure 5 page 38. 38. The Lokayukt has ordered for constituting the committee. He is one of the. Your lordship may
who is
kindly.
for the state? How do you control the office of the Lokayukt?
The matter is that we are not controlling, rather than since the office of Lokayukt is vacant, lordship, the post of Lokayukt is vacant, and as per the rule, it says that the appointment and promotion, these things can only be managed by the Lokayukt only,
कहाँ
lordship.
लिखे कौन सा रूल बताओ?
That is, lordship, I have filed my counter of it.
You got the counter. Will you show me the rule?
Yes,
Which
lordship.
rule are you referring?
From rule 13, lordship.
He is class 4, class 3.
Last.
बताइए.
At page number.
Rule 13.
Yes, lordship.
Rule 13 is power of governor to add or to the service for pension. Yes.
It is on page number, lordship. Page number 20. It is, lordship.
22 of your counter.
Yes, lordship. It is Jharkhand लोकायुक्त अधिनियम 2001, lordship.
वो इंग्लिश वाला नहीं समझ में आ रहा.
लॉर्डशिप इन दिस मैटर, लॉर्डशिप क्लॉज 2 जो है, ऐसे अफसरों एवं कर्मचारियों की कोटियों एवं संख्याएं जिन्हें उपधारा 1 के अधीन नियुक्ति किया जा सकेगा, वेतन भत्ते सेवा की अन्य शर्तें तथा लोकायुक्त की प्रशासनिक शक्तियां ऐसी होंगी जो लोकायुक्त के परामर्श करने के बाद ही विहित की जाए. लॉर्डशिप, सो द फाइनल action which has been taken, it has been
It's
taken.
a matter of promotion.
Yes, lordship.
So, yes, this rule is different from what you have referred. Yes, Mr. Srivastava.
Yes, sir, lordship.
Kindly see
ये कौन सा
rule
rule है?
19, lordship.
ये कौन सा
On
rule
page
है?
number 25, rule 19.
Just a moment. This is Lokayukt rule. Here's also an ex Lokayukt rule, but these are not matching.
मेरा सर्विस कंडीशन एक्चर 3 लगा हुआ है, गजट है, हमने गजट को नेक्स्ट किया है. पेज 24 if you know. Page 24 of the act application, that is extraordinary.
It is the act, lordship.
Yes, and this is the act.
ये क्या है पेज नंबर annexure 11 is what?
Annexure 11.
Yes.
This is rule. This is rules.
Rules, and what have you referred to?
I have referred that. Act. That was act. Act.
Jharkhand Lokayukt Adhiniyam. This is the act.
Yes.
Okay. You're referring to the act.
Rules must be in consonance with the act also.
You have referred to annexure A series, which is the act.
Yes, also.
This gazette notification annexure 3 is also the act.
That is service condition.
This is the rules.
Yes. And we are controlled by this. But he is reflecting that the act is
In this gazette notification, which is the corresponding clause? In this gazette notification.
so far Pronati is concerned, my lord. That is rule 9, section 9.
Rule 9 or section 9?
Section 9
Pronati. ये जो आप अभी रेफर किए थे, what is this? This one? At page number 55 is what?
55 is the rule. जो हम annexure 3 रेफर कर रहे हैं, उसी में पावर है रूल बनाने का, वो रूल बना है.
And annexure 3 is not the rule.
Annexure 3 is the act.
नियमावली ये
Yes.
भी तो rules हैं.
झारखंड लोकायुक्त कार्यालय अधीनस्थ कर्मचारी नियुक्ति प्रोन्नति एवं सेवा शर्त संवर्ग नियमावली 2021.
Rules है ये.
Yes.
हाँ, तो ये दो rules कहाँ से आ रहे हैं? There is another rule, annexure 11.
This is English version, your lordship.
Of the same rule.
Top में देखिए.
Of the same thing, it is English
हाँ,
version.
सबसे टॉप में देखिए.
Actual नहीं है,
Annexure
matching नहीं है. Matching नहीं है. आप
Annexure-
preliminary देखिए.
Annexure 11 का टॉप देखिए.
Annexure 3 and this 11 is not matching.
Your lordship में पहले से annexure 3 का.
Do you want to say that annexure 3 is the Hindi version of annexure 11?
Annexure 11 का.
Kindly see the rules. Is it
Yes.
matching?
Yes.
See rule.
Part 1 preliminary.
Rule 2 definition.
हाँ, rule 2 definition.
हाँ,
यहाँ पे
राज्य
rule
से
2
देख रोमन 1 पढ़िए. राज्य से अभिप्रेत है झारखंड राज्य और इसका रोमन 1 पढ़िए.
Rule 1 का 1.
Rule 2
हाँ 2.
कहाँ matching?
नियमावली.
It is not matching.
There is difference.
There is difference.
Annexure 11 is 2001 and it is 2021.
This is 2021.
Yes, annexure 3 is 2021.
This is annexure 11 is so this rule has been superseded.
Amended, up to date amended. ऊपर में लिखा हुआ as amended up to date. And this is on website.
So you are not governed by annexure 11, are you?
No, annexure 11 is the corresponding of annexure 3. I am just showing
No,
annexure
no,
3.
how can it be? Annexure
Annexure
3 and
three-
annexure
Annexure
11 are not
11
matching.
Yes. What
You
I
see,
am
once
saying-
there is a gazette notification, we'll go by the gazette.
Yes, gazette notification. I am
Show
also
me the
following.
corresponding provision which you have shown in the gazette notification.
Yes. Your lordship में करनी है the page 33 of the Gazette.
Okay.
29, page 33, Roman 2. 1 में क 2 लोकायुक्त कार्यालय में गठित विभागीय प्रोन्नति समिति की अनुशंसा पर विचार कर वरीयता सह योग्यता के आधार पर प्रोन्नति दी जाएगी. और annexure 5 your lordship mechanics.
And who will grant this?
Yes.
What will happen if the position of the Lokayukt is vacant?
Yes. Annexure 5 will also have page 38 of the brief writ application.
38.
G.
Yes. Yes, I'm there.
जी page 38. Yes. निर्देशानुसार कार्मिक विभाग स्वयं द्वारा गठित झारखंड लोकायुक्त कार्यालय अधीनस्थ कर्मी संवर्ग नियमावली 221 वही गजट जो है के वर्णित प्रावधानों के तहत लोकायुक्त कार्यालय में कार्यरत आशु लिपिक संवर्ग तथा सहायक संवर्ग के कर्मियों की प्रोन्नति पर विचार करने हेतु विभागीय प्रोन्नति समिति का गठन निम्न रूपेण किया जाता है 1 2 3 4 5 इसमें 3 तो गवर्नमेंट के हैं 2 मेरे लोकायुक्त ऑफिस के हैं। विभागीय प्रोन्नति समिति की बैठक लोकायुक्त कार्यालय झारखंड में सचिव महोदय के कक्ष में इतना बजे पूर्वाह्न निर्धारित की गई है। उपरोक्त प्रस्ताव पर माननीय लोकायुक्त झारखंड का अनुमोदन प्राप्त है। So this is the order of the honorable लोकायुक्त by which a committee.
Now, if a promotion is to be granted to you, then is it not required to be endorsed by the Lokayukt?
Yes, that has been done by Annexure 4, Annexure 6.
Annexure 6 is just a recommendation.
Recommendation
of the DPC.
उसके नीचे में जो है नीचे में देखिएगा 3 केवल अगर उस समय ये रोक नहीं होती तो मेरा नोटिफिकेशन इशू होगा।
ठीक है, लेकिन आज के दिन में नोटिफिकेशन कैसे इशू होगा?
नहीं, I think my lord now.
In absence of the Lokayukt.
Yes, that is for that purpose. Page 55 I was shown.
Page 55 is not matching with annexure.
No, I am not. It is not for that purpose. And rule उसमें secretary is the head of the office. It is
ऐसा
not
तो
for that.
आपके इस रूल में भी तो होगा ना? annexure 3 में
2001 में ही है।
2021 में बताइए कहाँ?
2021 तो अपॉइंटमेंट रूल है, वो अपॉइंटमेंट सर्विस कंडीशन का रूल है, Annexure 3, and that is the constitution and the function of the Annexure 11 is the rule regarding functioning of the office, day to day work. और इसमें रूल 25 बोलता है हेड ऑफ द ऑफिस हैज बीन डिफाइंड, सेक्रेटरी इज द हेड ऑफ द ऑफिस. How a state will control my office?
So state will not control
Now,
office.
by
State is
annexure-
saying that since Lokayukt is absent,
Yes.
he is not available, so they say
Notification
that
cannot be issued.
notification.
That is what my submission is. But for issuing notification, the secretary is sufficient. Lokayukt, honorable Lokayukt has no ministerial work. He will not work as ministerial work. That secretary is sufficient. He is the head of the office. And moreover, if the DPC has considered every aspect and passed an order recommending my name, what other impediment is there?
No, after all, the order of promotion has to be issued by some authority. Who is the authority who will issue it? The secretary?
The secretary by the Lokayukt. The Lokayukt will issue formal order.
Formal. So unless that formal order is there, how the promotion can be granted?
I think my lord, since this order.
आप भी हमको बताइए.
प्रोन्नति
बिना वो
के
formal
योग्य।
order के योग्य है सब कुछ है, लेकिन order of promotion has to be first issued by the office of the Lokayukt, and then only then only it has to be followed by a notification.
My lord,
In absence of Lokayukt, how this your promotion can be given effect to?
My lord, paragraph 18, I have read that statement because it is also what to. I am reading paragraph 18 of my written.
I will hear you tomorrow. What is the other case? We have a meeting.
Both
right
are
now.
similar. Only
Same.
two persons, two written applications.
Okay. Okay. We'll hear you tomorrow. Right?
Tomorrow I may not be there after.
आप सुन लिए ना, आपका
हाँ, ठीक है।
जो ऑर्डर करना होगा हम समझ कर कर लेंगे. These two cases को the argument has remained inconclusive. आप लोग अपने appearance दे दीजिए. आप तो रहेंगे ना कल?
He will be.
ये वाला एक्ट हमको जरा दे दीजिए. Close this case tomorrow. आप लोग, आपका क्या stand है? आप
हम तो
neutral हैं?
सपोर्ट कर रहे हैं उनको. हमारे यहाँ से जो रिकमेंडेशन हो गया है, रिकमेंडेशन ऑन डीपीसी हुआ. डीपीसी में 5 members committee were there, my lord. They have recommended the name of the petitioner from.
रिकमेंडेशन होने के बाद बहुत जिम्मेवारी से बोलिएगा, आपने काउंटर फाइल किया है?
My lord, since there is no Lokayukt, so my counter is.
हाँ, इसीलिए ना, आप तो काउंटर भी फाइल करने की स्थिति में नहीं है बिना ऑनरेबल लोकायुक्त के, तो प्रमोशन कैसे दीजिए?
सेक्रेटरी साहब की तरफ से फाइल है, लेकिन वही है कि हम जब तक है नहीं,
जब तक एक प्रमोशन का ऑर्डर जब तक एक हेड ऑफ द इंस्टीट्यूशन से अप्रूव नहीं होता है, तब तक नोटिफिकेशन कैसे हो जाएगा? रिकमेंडेशन इज वन थिंग, ग्रांट ऑफ प्रमोशन इज अ सेपरेट, भले वो फॉर्मल ही सही, लेकिन वो उसके बिना कैसे हो जाएगा नोटिफिकेशन?
Well, this situation was not foreseen by the legislature.
I
Therefore,
know.
this thing happened. But I think, my lord,
लेकिन नॉर्मली क्या होता है स्टॉप गैप अरेंजमेंट रहता
Yes,
है
but-
लेकिन इसमें कोई स्टॉप गैप
नहीं
हो
है,
नहीं सकता
नहीं हो
है
सकता।
हो नहीं सकता है।
exactly. Therefore, my submission would be at
अब
this
वही
aspect.
बात है ना, मान लीजिए कोई चीज ऑनरेबल गवर्नर से साइन होना है
उनका
और वो
replacement
वेकेंट
नहीं।
रहे भले
But
एक दिन भी,
I do
नहीं हो
agree.
सकता
I
है
do
ना।
agree. But I think, my lord, your lordship may.
we will protect your right,
Because मेरा तो notification
we
होना है,
will
तो उस दिन
protect
से ही
your
होगा।
right।
तो जब साहब आएंगे तो हमारा
हाँ तो
notification
वो हम
होगा।
ऑर्डर कर देंगे,
I think
है ना, उतना ही ऑर्डर कर देंगे, लेकिन उनके एब्सेंस में ये ऑर्डर नहीं हो सकता।
नहीं ठीक है, हम भी समझ रहे हैं, हमारे वो टेक्निकल
एक
प्रॉब्लम
बार
है,
गजट
post
को
cannot
एक बार गजट को फिर से
अब आप जानिए भाई, आपका ऑर्डर है तो आप तो उसको पुश करने के लिए लगे हुए हैं, लेकिन आप बताइए बिना ऑनरेबल लोकायुक्त के आप यहाँ पे काउंटर एफिडेविट फाइल करने के लिए भी सक्षम नहीं है उनकी तरफ से, तो फिर थोड़ा सा टेक्निकल चीज़ों को ध्यान रखना जरूरी है।
One matter I have mentioned in the morning, Lordship. Lordship, उसमें